Justice of the Appellate Division 4th Department. Hear ye, hear ye, hear ye. All persons having business to be before this court shall draw near and give their attendance, and they shall be heard.
Please be seated. First case for oral argument this morning is 410 People versus Whaley. No, apparently your opponent has checked in. Is Marie McCarthy here? Apparently not. Okay.
Your Honors, Brad Oster for the People. I think I don't really have anything to add from my brief. If there's any questions, I'd be happy to field them.
Thank you.
Okay, thank you.
For 11 People versus Grady.
May it please the court, Scott Porter for Mr. Grady. I want to address the point 1 in my brief, which has to do with the mission of the mugshot of Mr. Grady. I submit that as Judge Doran said, the photo is prejudicial, but he said that it had sufficient probative value to justify its admission. And I submit that the people were looking for some kind of change in Mr. Grady's appearance that would justify its admission. It offered 2 rationales. One was hairstyle, length of hair, but because the robber was wearing a hoodie, one could not see the hairstyle. And then at trial, the people argued change in skin color. And it's difficult to tell in this record, and I draw your attention to page 550, because I submit that Mr. Grady, his mugshot, his skin appeared paler than it was, darker than it was in real life. And for the people to argue that it wanted to show one of the witnesses' testimony to show that he had pale skin, to introduce a mugshot that shows the defendant with darker skin simply does not make sense. But even if this court found that the people did want, or the people's mugshot, his skin was paler than it was in real life, I still submit that it should not have been admitted, because this witness did not use skin complexion as a reason why she identified the defendant.
Well, one of the witnesses may refer to in her testimony skin tone. That was
Right, and there's a lot of other features to the perpetrator that.
Let me ask you something,
Yeah.
Counselors. How can this be a harmless error analysis?
I want to quote you what I thought trial counsel did an admirable job in defending this case. And his theory of the defense was, quote, 3 extremely damaged, very suspect and very tainted IDs, unquote. And the jury deliberated 2 days before they convicted Mr. Grady. And for each of these 3 witnesses, there are significant issues. So,
but isn't the combination of them, you know, the one says, I think I recognize them, she goes, checks with somebody else, they know, and then Flynn says, yeah, that's my knife from my roofing company and the hoodie that I gave him, even though it's inside out. I mean, it seems there was a combination of factors making the identification.
which I think begs the question, why admit the mugshot? It was prejudicial.
I agree. I mean, it appears to be an overkill, so to speak, when you have the video of the robbery, you have the victim identify him, you got another person come in and identify him in the video, you got his former employer of 30 or how many years ago, or has known him for most of his life, identifying the knife, identifying the hoodie. Yeah, I think it's, I can see the argument. Yeah.
And I think the motivation to admit the mugshot was to get a certain angle of the face so they could juxtapose that with one of the screenshots from the surveillance footage.
Yeah.
And that was the purpose, to have it admitted. And
Fair
for
enough.
that reason, they were looking for a change of appearance. Thank you.
Thank you.
Good morning, Your Honors. Ken Tyler for the People. I'll rely on the brief we submitted to Justice Centra's point. I would argue I don't think it was error, but I think it was harmless as well. Justice Niemoyer's point, there was also an inculpatory jail call and particular sneakers that were in the video. Thank you.
Thank you. 412, People versus Johnson.
Morning, Your Honor. Please the court, Paul Watkins representing the appellant. This is a clear case of no probable cause for any of the board levels. Initially, the level 1 inquiry. It's clear that all that the police officer saw when he pulled up was my client move from the driver's seat to the passenger seat. That is clearly not enough for him to make a level 1 inquiry. All he should have done was kept on driving down the street. My client was doing nothing that would justify him pulling over and.
Well, so you've got him jumping from the driver's seat to the passenger seat, coupled with the fact that this is a high crime area.
I'm sorry, coupled with what, Your
You don't
Honor?
need much to justify a level 1 inquiry.
I'm sorry, I didn't hear coupled with what?
Coupled with the fact that this is a high crime area. He was purposely patrolling in this area because there had been an uptick in crime in the area. So you've got that, and you have this defendant jumping from the driver's seat to a passenger seat in a parked car. This is just a level 1. At this point, we're just talking about level 1, and the bar's not that high for a level 1 inquiry.
Well, Your Honor, I understand that, but the officer did not articulate that a high crime area was the reason he stopped. He said the reason he stopped is he pulled up 50 feet away, saw my client move from the driver's seat to the passenger seat, and thought that was enough. It's clear under the cases that I cited, even when a driver in the car pulls something from the glove compartment and puts it on the floor, that's not enough. My client may be changing seats, and also there's an issue about jumped or moved because the police officer was impeached by his grand jury testimony concerning that. So there's just not the predicate that's needed for him to even approach. He should have kept on driving his police car and not even bothered to approach. Now for the level 2, the reason he went ahead and followed my client to make a common law inquiry was because he said my client adjusted his pants.
He was pulling up his pants were unbuttoned, he seemed to be adjusting, trying to buckle the belt.
But Your Honor, under the cases I cited, that's just not enough for a level 2 inquiry. Just because someone's adjusting their pants with nothing more is not enough for the police officer to follow him and start making a common law inquiry to him. Now, for the level 3, the stop and frisk, the officer needs to have an articulable reason my client somehow was suspected of doing a crime. There's nothing to support
Or
that.
that he posed a threat to his safety. That was the reason that he gave for justifying the pat frisk.
I'm sorry, Your Honor?
He justified the pat frisk because he was concerned that the defendant might be armed and posed a threat to his safety.
I understand that's what he said, Your Honor, but what is the reason for that? He didn't see any weapon.
Well, it's all of the conduct leading up to that, jumping from the passenger seat, and then there was some more movement, that he made before he got out of the car, moving to the driver's seat as if he was, according to the officer, trying to hide something. Then he got out of the car, and then his pants are undone, he's pulling them up, he's trying to rebuckle his belt. He said, that's often conduct that defendants often secure weapons in their pants with a belt. So he gave all of that explanation.
I understand, but getting back to the initial thing about moving back from the passenger seat to the driver's seat, there's an issue about that because he was impeached by his own grand jury testimony, and his police report where he never mentioned that. All he said in the grand jury was, I saw him move from the driver's seat to the passenger seat. He didn't say anything about reaching back over into the driver's seat in his grand jury testimony. Now, also for the stop and the pat and frisk, I cited the cases where, no, the officer said he adjusted his pants. That's not enough. He was nervous. That's not enough. He said, and
All
then,
by themselves, they're not enough, but we've got all of these things in this case.
Your Honor, but if you look at it piece by piece,
Right, but
the
Mr.
whole,
Watkins, you can't look at it piece by piece. You've got to have it all together to see what there was. But we'll look at it very carefully.
Your Honor, but I would say that if you look at each piece, level 1, 2, and 3, it does not support him doing any of those. So now the other issues about the intent to sell, my client had no drug paraphernalia. He did not have a weapon. That's one thing about the search. Everyone agrees there's no weapon. No outline of the weapon, no reason to search him, no weapon was found. No cash, no drug paraphernalia, just 15 decks of heroin and a package of cocaine, which their own expert said was not outside of personal use. Their own expert said the 15 packages of heroin.
But the experts said that a user would typically not have both heroin and cocaine on them.
Well, Your Honor, that's correct, but at the same time, we had 15 packages of heroin, 1 package of the crack cocaine. But that's just one factor. But their own expert said the 15 decks of the heroin was consistent with personal use. In fact, he said 20 decks would be consistent with personal use.
We're aware of that.
Excuse me, Your Honor?
We're aware of that.
Yes. And then finally, I did write in my brief the issue about the being penalized for going to trial. This whole case here was just a, sort of a outside liar to the underlying burglary case. This case would have been dismissed. My client never would have had to do anything with this under the plea agreement that was made in the burglary case. Instead, he's now faced with having consecutive sentences to the burglary charge. And as I said in my brief, I believe that supports a finding that he's penalized for going to trial. Unless there's any further questions, I'll submit.
Thank you.
Thank you.
Morning, Your Honors. May it please the court, Scott Miles for the people. Under the totality of the circumstances, which is what we have to look at for a suppression issue, the officer's actions were justified at each escalating stage of this encounter. The level 1 inquiry was justified by, as he testified, the fact that not only was it a high crime area, but specifically it was a rising violent crime area. There had been a number of violent crimes in that area. And it was on that basis that he saw the defendant, as the officer was approaching in his car, jump from the driver's seat to the passenger seat, reach over and appear to pick something up from the driver's seat. That was what drew the officer's attention and initially roused his suspicion. And then, as the court is well aware of, all of the factors that went into the escalating steps that the officer took from that point on, it's the people's position that the totality of all those circumstances justified the officer's actions. In regards to the sufficiency of the evidence of intent to sell, there was the fact that the defendant had different kinds of drugs, that they were individually packaged for sale, the fact that he did not have any of the paraphernalia that would be necessary to actually consume either of those drugs on him. All of that amounted to a legally sufficient evidence that the defendant did intend to sell those drugs and not possess them for personal use. Unless there are any other questions from the court.
Thank you.
Thank you.
People versus Roberto Leon.
Good morning, may it please the court. Nelson Torrey on behalf of Roberto Leon. There's several serious legal issues in this case. My client's right to a trial by jury that was chosen and sworn was violated.
Mr. Torrey, what do you think the court should have done differently?
Let the sworn juror remain seated and decide the case. 7 witnesses had already testified under oath before that juror and the other 11. And that juror was not shown to be grossly unqualified in that he evidenced any hint of lack of impartiality.
The fact that they broke one of the juror commandments, so to speak, by admitting to the court that they spoke to their spouse about not only what the case was, but how they felt about it. Isn't that something that's very serious?
From the colloquy, I took it that the wife had spoken to the juror more so than the juror had spoken to the wife. She knew he was on jury duty, and she said, I was on a grand jury, just don't be the foreman. But that's not grossly unqualified, especially when he said he could return a verdict based on the evidence and in favor of the people if the evidence so warranted it.
But it seems that the court excused this juror because the juror expressed fears for safety, fear of intimidation. And
It was all very vague, my reading of the record. He indicated that he thought he recognized the guy in the gallery because that guy used to go to a bar that the juror would go to.
Right, I have no problem with that part being kind of muddled, but at the end of the day, he clearly said, yes, he'd been thinking about this and he was afraid, and he hadn't stopped thinking about it for 3 hours.
He said he wouldn't be fearful if he ran into that person on the street.
But he also said, my wife is intimidated. She asked me not to be the foreman. She asked me a couple of things. I don't know. I'd say yes because of fear of my family is all. I mean, that's the juror's actual words.
Well, the
And
juror
you're telling us
said,
that the juror didn't indicate that, but from hearing that, it appears to me that it was instilled that not only was he concerned, but he was more concerned, he was maybe more concerned about his family than he was himself.
the Buford rule really requires that the juror evince an unequivocal state of mind that keeps him from being impartial. This juror did not. He repeated about 3 times that he could be impartial and he could follow the law and decide the case on the evidence. He did mention, in fact,
But after that, when he was asked whether this fear would enter into his decision-making process, as to whether he would find the defendant guilty or acquit the defendant, he said yes. He would hesitate in his decision because, as Justice Centra pointed out, because of fear of my family.
a lot of jurors find a lot of ways to get out of jury duty.
I don't think he was trying to get out of jury duty, he was already there.
He was on, and it
But
was...
we'll
yeah.
look at that very carefully. Do you have another argument?
Yes, the proof itself was conflicting, it was sketchy, it was weak. Villegas was the brother-in-law of the defendant. His story was completely different than this guy Rodriguez, who was supposedly at the house, who didn't see the shooting but said he heard it. And then Rodriguez is allowed to testify to some hearsay statement by Villegas that Villegas never mentioned in any of his testimony. It's basically a one-witness case by this Villegas who's under federal charges and is cutting a deal on the federal charges to testify against his brother-in-law. What's more is...
Well, that was all before the jury. I don't disagree that there's some inconsistencies in the testimony of the different witnesses, but Villegas was right there when this shooting happened.
Well, the
And he
problem is he
testified-
never identified the defendant until 9 months after the fact.
And there were reasons for that, but, okay.
He's his brother-in-law. Who knows what his motives were at that point? But that's a very questionable issue when it comes to the legal sufficiency of the proof and also the weight of the evidence.
Well, there's also surveillance footage that shows the defendant firing repeatedly at the victim.
I would disagree, Judge. There's no way to identify anybody in that dark surveillance video, and that was very clear on the record. So identity was the entire issue of the case. And for that reason, when you look at 2 witnesses that have just a ton of baggage, and both of them have motives to lie, Rodriguez was being paid by the district attorney's office money. He had a bunch of criminal charges in his past.
We know all that.
So this is when people get convicted that shouldn't be convicted.
And we'll look
And
at
that's
that
why I
very,
say
very
this
carefully.
jury was sworn and should have been allowed to decide the case. That's all I have.
Thank you very much.
Morning, Your Honors. May it please the Court. Michael Hillary for the people. I'll just speak briefly to the point about the juror disqualification. Everything the court said was what I intended to say. I would only add that the court reached that decision in anything but a hasty fashion. There was a good deal of questioning involved, and it was a careful decision. The jurors' attention, regardless of what the reasons were, was unacceptably divided over a three-hour period. As to the proof, the court has already pointed out the surveillance video. It aligned very well with the testimony of Villegas. It also aligned with the testimony of Rodriguez, who put the three individuals, defendant, Rivera, and Villegas, together, moving away from the building and out of his sight. The excited utterance, that was not contested. The quality of the statement as being an excited utterance. The challenge to that was only that it was an attempt to backdoor that information in to the jury, because Villegas himself didn't testify that he shouted, Roberto shot him. But that's, I think, a red herring. Villegas was never asked about what he shouted, what he said at that point. And given that all the criteria were met, it was fairly admitted. You had the .38 caliber shell casings. It was determined that there was a high probability that the bullets that were fired from a .38 caliber gun. The firearms examiner couldn't say that definitively, but to a very high degree of certainty. That aligned with the witness's testimony that Villegas saw him draw what appeared to be a revolver, a .38 caliber revolver. In addition, you had defendant's own statements. Defendant spoke to the probation officer the day after the event in question, and for the first time in the life of his probationary status with this particular officer, indicated that he wanted to go see his mother in Puerto Rico. That itself wasn't suspicious because his mother was in Puerto Rico, but it was the first time he'd ever asked, coincidentally a day after the shooting. Secondly, he indicated that when that was denied, he indicated that he wanted to go with his boss to Florida. Once again, something else that the defendant had never requested until a day after the shooting. So you've got a bunch of circumstantial proof here that links defendant to the scene, in addition to the video, which corroborates the witness testimony.
Thank you.
Thank you.
People versus Dalbrian Grosvenor.
Good morning. May it please the court, Caitlin Guptill on behalf of the people. Unless the court has any questions, I will rest on my papers.
Thank you.
Thank you.
416, People versus Ryan Reeder.
Good morning, Your Honor. I'm Charles Greenberg, representing Ryan Reeder in his appeal for criminal possession of a controlled substance in the 7th degree rendered in Seneca County. My first argument, which I believe to be the stronger of the two arguments, was that there was no basis for the police.
Yeah, your brief seems really focused in on, which is an interesting issue.
Yeah.
Is the recently committed.
The recently committed,
That's the word.
yes.
But I noticed you didn't cite case law that supports that an officer who sees a crime and then waits a period of time, no different than like an undercover officer, and then waits a period of time and then stops the vehicle and arrests the individual. And your argument is that because it didn't happen simultaneously, therefore the stop was improper.
Well, I thought I had cited the Spencer case in my brief for that proposition. I mean, the argument that I was making there, that Detective Vine was investigating this, a completely different crime in Ontario County, signed the warrant, or signed the felony complaint, and then orchestrated this whole drug buy, which basically created a new crime. But, what does that add to the equation? If he had the felony complaint.
Well, he didn't pull him over for that crime that was just committed in Rochester. He was pulling him over for a crime that was committed, was in October, was it? Or
Well, the
September?
date that he was arrested at the Waterloo Walmart was October 10th, 2017, but I think that the crime
was predicated on September 20th.
Yes, so that was much earlier. He was free to just go arrest Ryan at his house, or he had two jobs, and there was no reason for this whole crime fact pattern of getting the confidential informant to go to Rochester to buy drugs. I mean, that just turned out to be an entirely different crime. And also, by their own admission at the suppression hearing, Your Honor, is that they lost contact with him for a while when they were in Rochester. They regained contact when they were on the, I believe it was on the 490 as they were coming back to the Interstate 90
Yeah, no, but
intersection.
the court heard that testimony and found that it wasn't possession with intent, that it was possession for personal use, 7th degree.
Right.
I mean, your argument here seems to be simply that the stop was bad. It was bad basically because the crime took place a couple of weeks before they stopped the vehicle.
Yeah, that would be exactly what my crime is, that this entire, it wasn't necessary for them to do all of this. They could just, it's just
We
kind of a
understand that
rustic-
argument.
Yes. My second argument is I'd like to just take a look at the entrapment defense, and it wasn't really brought up before in the lower level. They did bring up agency, but agency doesn't really apply to possession as it does to sales, but I would like to at least consider that to see where it would go. I'd be happy to answer questions about it if you wish.
Thank you.
You're welcome.
Good morning. If it pleases the court, Mark Sinkowitz for the respondent. I would just like to address the point with respect to the reasonable suspicion for the stop. Our position is that Spencer is distinguishable. The proximity of the crime to the stop, I think in this case, is not as important because the defendant committed the crime, whereas in Spencer, the stop was predicated upon further investigation. And so I think that that standard of being closer in proximity to the crime is more important than in our particular case where the defendant actually was suspected of committing the crime and was going to be arrested. And with respect to the second point, the record, I think, is fairly clear that at the very least, the defendant was predisposed to the potential crime, which is one of the 2 requirements for the entrapment defense. And unless there are further questions, I'll rest on my papers.
Thank you. 417, People versus Baltazar Lopez.
Please, the court, Shirley Gorman for Mr. Lopez. I assume the court received my additional case citation, People versus Mercier, which not only decided the same issue, but granted the relief that was suggested in both my brief with consent of the people. And as the court's also aware, I'm arguing that the sentence should not have been enhanced based upon the testimony of the probation officer. Unless there are questions, I'll rely on my brief.
Thank you.
Good morning again, Your Honors. It's people's position that the testimony at the Outley hearing did justify the enhancement of the defendant's sentence. Unless there are any other questions, I'll rely on my papers. Thank you.
418, Alyssa Mays versus Tyler Green.
Good morning, Your Honors. Valerie Barbic for the appellants. This is a situation where I would ask this court to adopt the Court of Appeals analysis in the Andino case when determining whether something constitutes a collateral source. In this situation, we submit
So you want us to find that sequentially, according to Andino, the first part was for lost wages at age 63 when her economist testified she would retire, it converts to a pension, and then it is not a collateral source.
Right, it's a collateral source up until age 63. The jury awarded her 9 years, and we're only asking this court to reduce by the 9 years that she got those collateral sources. I mean, they act as a wage replacement. She wouldn't have been entitled to them unless she was disabled. The other piece is on the workers' compensation. She received benefits in excess of $100,000. I think it was actually $190,000. The workers' compensation carrier will never be able to pursue
The first
payment
50.
of the $50,000.
The first 50,
And
which
we
is in lieu
salute
of no fault. So let me
Correct.
just ask you a question about that. I recognize that you don't get a lien on that 50, but it seems that the court, when the case went to trial, the plaintiff was prohibited from proving medical expenses because she was reimbursed through the workers, from the workers' compensation carrier, the payments, which represented no-fault benefits.
Yeah, so she was actually prevented from putting in the proof because she didn't, disclose it and bring in the requisite witnesses to testify.
Well, she wouldn't have been able to, generally, they're not well, I suppose sometimes you're permitted and then it's offset
And then
as a
it's
collateral
offset,
source.
correct. But in this case, it wouldn't have been offset because it's lienable. I mean, normally you offset by the collateral source, but because the workers' compensation carrier wouldn't have been able to collect all of that back had the plaintiff put in the requisite proof. All the plaintiff needed to do to put in that proof was call the, could have called the billing doctor, billing
Right.
department person and said,
But the
these were-
first 50 is not lienable.
Correct, the first 50. I mean, I think the plaintiff's basically saying, oh, well, the first 50 went to medical. I don't think the plaintiff can allocate it that way. The bottom line is.
How can we, I'm not so sure that you have made a showing to us as to how we can allocate, how we can determine that the first 50 was payable, is actually.
I don't think it matters, Your Honor, respectfully. I don't think it matters. I think the bottom line is she received a benefit for lost wages for which no fault was responsible for the first $50,000. I mean, it almost seems like it would be prejudicial. I mean, would it be that the workers' compensation carrier would have to delineate in order to assert a lien?
But how do we know that there was really a double recovery for that? How do we know that
By
the first?
virtue of the fact that she received $190,000 in lost wages and then far in excess of $50,000 for medicals. I mean, however you shake it out, the bottom line is she did receive lost wages from the jury, and she did receive payments for lost wages that she does not have to repay.
Thank you.
So, thank you. There's no further questions.
419 Charles McKay versus Finger Lakes Traffic Control LLC.
Good morning, Your Honors. May it please the Court. My name is David Katz, and I represent the appellants. This is a single vehicle, motor vehicle accident involving a
We're well aware
motorcycle.
of all the facts.
I'd like to devote my time really to the Espinal issue and discussing the launching of an instrumentality of harm. This is, in some ways, I was talking with a colleague about this, takes you back to 1L torts first year in law school, nonfeasance versus misfeasance.
Let me interrupt you, because we've been through law school and all that. How is this situation any different than the Shozak case? I hope I pronounced it right. Why don't you get us right to that? We, people on the Fourth Department went one way, the Court of Appeals then tells us that a case just like this, it was a question of fact whether there was an instrument of harm launched by leaving an uneven, pavement, just like this case. I see them very, very similar.
Well, the difference as it relates to Finger Lakes is that the claims against Finger Lakes don't actually relate to the bump.
No, but so the claims against you relate to signing,
And that is
warning, right.
And that is the key difference with that case, is that the bump would be something that would be outlaid, right? You would put it down or you would create it in some way. The signage claims are not that. The signage claims are not that we created a dangerous condition, it's that we didn't put more signs out. That's what the plaintiff claims. And that's not the appropriate analysis under Espinal.
Why not? Why not? Why can't, if actions and inactions can constitute a tort, why can't action and inaction satisfy the Espinal exception?
It comes back all the way to the cases that led into Espinal, specifically the Mock case, M-O-C-H.
No, we're familiar with all those cases. I guess my point is, so the claim against you is that at the end of the day, the overnight signage was inadequate. You either took some down or you didn't place enough signage after, when you left, when you were leaving the work site, when you were preparing to leave the work site. It seems to me that that could be action or inaction, and it seems to me that that can satisfy, that can be launching an instrumentality of harm. It can be, it seems that it satisfies Espinal.
I don't think it does, Your Honor, and the reason is, again, it's not like the bump, it's not something that's put down, and that's the basis of that exception, is that you have to take some step toward and make something more dangerous.
Well, how about removing a sign? Isn't that taking a step that might be creating a more dangerous condition?
Well, the removal of a sign could be, although here you have a difference between daytime signs and nighttime signs, and that's a key difference. The other difference here that's very important to this case is that New York State accepted what was done by Finger Lakes. And as we cited in our briefs.
So there was an inspector from the state there that day that accepted it?
Yes, there was. And that in and of itself is sufficient to show that there was no dangerous condition presented by the signs.
Because that person is the decider of that?
In this context, yes, because the contract ultimately flows up to New York State. New York State sets standards and specs, but ultimately it's New York State's choice what to accept and what to put out. And there was unrebutted evidence that there was compliance with New York State's directives. And ultimately, what New York State says to do is what a contractor is to do. The contractor is the...
Let me just clarify something. So you say that on the day that this accident happened, a state DOT inspector came by at the end of the workday to say, yes, your evening signage is in compliance.
I believe that was the testimony, yes.
And that's uncontradicted.
As far as I know, yes, Your Honor, that is uncontradicted. The New York State employee
We'll
who
look at that.
testified.
That's not quite how I recall it, but we'll look at it.
And then the other issue I wanted to touch on, Your Honors, is the proximate cause issue. This is an accident where the plaintiff can't remember anything. The only other potential witness, plaintiff held them out as a witness, but it's fully unclear that they actually were a witness to the accident in any way. Everybody tried to get him, couldn't get him. He's functionally unavailable to everybody. So this is a case where there's an unwitnessed accident, and there's no evidence beyond speculation that any lack of signage actually created or caused this accident. Now, that may be different evidence as to the bump.
Doesn't the law give those individuals sort of a presumption, that, we don't penalize them for not being able to tell us as a result of an accident what happened. We're able to look at the circumstances,
I think 2 points there, Your Honor. The noseworthy concept, one, only applies where there is some sort of disadvantage. And here, because it's unwitnessed, there is no disadvantage to the plaintiff or the defendant. And more importantly and more fundamentally, even if noseworthy applies, it doesn't allow for speculation. There still has to be some evidence that can lead to an inference. And here, there simply isn't any as it relates to signage. And
Thank you.
thank you.
Good morning, Your Honors. Matt Kaiser for the respondent, Charles McKay. And I just want to address obviously the Espinal argument that was just put forth by opposing counsel. There was no prima facie showing that Finger Lakes complied with the contract, and there's no question that Finger Lakes would be bound by the contract, meaning the contract with the state. There's no argument that this contract was complied with. They point to the stamp of approval by the DOT inspector at the end of the day. I cite Schilling v. Malark because that case clearly says that if the testimony of the DOT inspector is conclusory, if it doesn't have a factual foundation, it's not enough to establish entitlement to summary judgment. And I think that's sort of the situation we have here because there's an internal contradiction on the face of the moving papers. Was this left northbound lane even open to traffic? If it was open to traffic, there were a number of things that had to be done under the contract. There had to be channelizing devices. There had to be certain signage. Look at all the photographs, look at all the testimony. That was missing. So if the state thinks this is closed, and that was the testimony of the DOT inspector, and if Finger Lakes says it's open, that was the testimony of their supervisor, how is my client going to know if it's open or closed? And if my client doesn't know if it's open or closed, I mean, there's no channelization. He doesn't know where he's going. I think that on this record, there are clear issues of fact as to whether Finger Lakes launched an instrument of harm by failing to discharge their duties under this contract. And they did affirmatively remove channelizing devices at the end of paving operations that day. That is an affirmative act. So I think that the nonfeasance argument does not hold up. Unless the court has any questions, I'd rest on my brief.
Thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, Elizabeth Ognanovsky for Seneca Stone Corporation. Specifically with regard to Finger Lakes' appeal as to contractual indemnification. Since this action was commenced in June of 2018, there's always been an understanding that there was an agreement, and there's never been a dispute that there was not an agreement between Finger Lakes and Seneca Stone that applied to the Route 14A project. Finger Lakes asserted in their answer a cross-claim for contractual indemnification, breach of contract. They also made a similar explanation basis in their verified bill of particulars. And when Seneca Stone served them with a notice to produce, Finger Lakes employee Craig Southard actually emailed the project superintendent for Seneca Stone and asked whether there was a contract that applied. And that was on December 3rd, 2018. The email in response from Jim Dalrymple of Seneca Stone specifically said that the prior agreement that had been used on a prior project had been extended and applied to the Route 14A project. Again, that was on December 3rd, and then in response to the notice to produce on December 28th, 2018, Finger Lakes disclosed the same agreement that it's now disputing did not apply. Our demand specifically asked for any agreements, addenda, exhibits that applied for the work at the site at issue, and that was the one that Finger Lakes had supplied to us. When Finger Lakes employee Kevin Fruitt was deposed, he testified after reviewing the agreement that he was familiar with the contract and that the contract applied to the project. And specifically, he was asked, and this is in the record on 548, is it your understanding that all the terms of the agreement apply to the 14A job as well as the bridge job? Kevin Fruitt testified yes.
So are you arguing that you were entitled to contractual indemnification? 'Cause you did not cross appeal, right?
No, I did not cross appeal. I'm arguing that the lower court's holding that with regard to.
That there was a question of fact as to whether there was a contract
Correct.
in place.
Correct.
That was appropriate.
Correct.
Okay.
I think we have that.
Thank you.
Thank you. 420 Robert Stern versus Golub Corporation.
This side or the other?
Right here. You're Mr. Stern?
Thank you.
Mr. Stern, yeah, you can come right up here. You're going to start.
Thank you. My name is Robert Stern. I'm the plaintiff. I'm a pro se plaintiff appellant. And I'm here because I submitted a properly made motion. The defendant respondents replied. I felt that one of the defendants didn't respond timely, with a little back and forth with the court. The court agreed to give me additional time because Price Chopper had taken a little extra time. The papers were submitted. They responded. The court said, you can respond if I do that before July 1st. I responded June 28th. The court then decided that they weren't going to hear my reply to the defendant reply because they wouldn't have an opportunity to respond to it. My position was they don't get the SIR reply. They had already replied once, both of them, and I didn't feel that CPLR permitted them to reply to my reply to them. That's one issue. The next issue that I had in looking at the papers, the brief from Price Chopper and Mr. Betsy, the court had a duty to, the court below had a duty to make decisions on the law that was promulgated by this department, the Fourth Department. Nowhere in Mr. Cunningham's brief did I see any law that to support his arguments that were Fourth Department. The other argument I had was a duty to preserve the evidence. And we had contacted Price Chopper after I had been struck by the...
Yeah, but it's my understanding that they did provide that.
No, they provided a video. The court below said if you can give them from a video from 1 o'clock to 2 o'clock, 1 hour, that should do it. But what they did was they eliminated the part of the video that showed Mr. Betsy driving recklessly. I had claimed that he almost ran me over earlier. If they had been, if they had had their observation cameras on and were live monitoring, they would have seen Mr. Betsy doing that. But that was cut out of what was given to us, hence the spoliation. In any event, that was another part of it. I felt I was entitled to an in-camera review of their claims file. They're claiming that it was...
Well, if there was going to be an in-camera review, it would be the court.
I'm sorry, ma'am, I didn't hear.
If there would be an in-camera review, normally it would be the court that would do it.
Yes.
So...
Yeah, exactly, but the court didn't do it. And they're claiming that it's all information, lawyer to client, and it's not admissible.
So it's privileged,
that it's privileged. And I said, well, we don't know whether or not it's for mixed purposes unless we do that in-camera review, but that wasn't even considered. I don't feel that they were responsive to my bill of particulars request. If I stated in my bill of particular request, please state the facts, statutes, case law that support your position, and they tell me, well, I've given enough information on that.
We'll look at that we can look at.
I'm sorry.
We can look at that very carefully, because that's right here.
I don't think I heard you properly.
We'll look at that very carefully.
Oh, you will, okay. They also claim that they didn't have notice of Mr. Betsy, no one telling them that Mr. Betsy was driving recklessly. Actually, they had constructive notice. This court has ruled on constructive notice. The Court of Appeals has ruled on constructive notice. They were aware, and we have testimony from their store manager, that they were aware of other accidents. Being aware of other accidents...
Are they aware of this particular motorized cart operator?
No, they weren't live monitoring the premises because they didn't have sufficient staff, which they also admitted to live monitor. So they would do it after the fact and perhaps see that there was something wrong, but that doesn't stop someone who's being reckless early on from being caught, and that was the problem there. They had constructive notice that these things are sometimes misused, the motorized shopping carts. Matter of fact, that's why I walk like this today and I shake, because I have a shunt in the back of my head from being hit with that. Mr. Cunningham referred to it, they bumped into me. Hell no, he hit me from behind and knocked me silly. Anyway, not to get emotional.
Yep, don't get emotional, because you're doing a great job. Just
Thank you. You're kind. So We did discuss there's the absence of Fourth Department law in their
Right, we have all
briefs,
that.
and duty to preserve the evidence, and which they didn't do. My son, who is an attorney, who practices law in Colorado, contacted
He's
their...
the one that asked for the films, right?
Yes. So within inside of a couple of weeks, they replied, so I know that they were on notice, and they sent us a letter saying they had preserved the evidence. So they had
And
that notice
they
well...
did preserve what they thought they needed to preserve, and that's something you've already discussed, and we'll look at that.
Okay. Yeah, that notice was long before any automatic deletion process would have started for
I
them.
understand all that.
And so they were obliged to, so what they did was, the minutes early on when Mr. Betsy was tooling around and almost ran me over, that wasn't even in the video.
Right, we've already discussed that. Do you have anything further, because your time's almost up?
Okay. I did 10 minutes already?
Almost.
And I have given you that they didn't consider my reply, and the reason the court gave was they didn't have an opportunity to reply, and my argument was that they don't get to reply. They already replied once. And that's it, unless you have any questions for me.
Any questions? Thank you very much. Oh, Mr. Stern. Mr. Stern? Have a seat right there.
Oh, I was going home, Your Honor.
Not yet, not time yet.
I don't know how you folks get up so early and come in and hear cases, but this is not for me.
May it please the court, my name's James Cunningham. I represent Price Chopper in the case, and I'm just going to address the very few points that Judge Neary decided on the underlying motion. And one of them was not the video or spoliation. That's not part of the order. It's not in front of this court. But I'll address briefly, we did provide the video that was requested. Of the accident, I think it was an hour before and an hour after that was provided, and that's all that was requested. But again, that was not decided by Judge Neary and is not before this court. What's before this court are 3 discovery issues. One was Mr. Stern's request for all accident reports. And our position on the underlying motion was that there was no defect in this motorized cart. There's no claim that there was any problem with the cart at all. The claim is that Mr. Betsy struck Mr. Stern with the cart. So Judge Neary found it was more of a notice issue, and he said, well, I'm going to give him 5 years.
5 years instead of 10.
Right, and so we complied. We provided the 5 years of accidents, and that's not on appeal, but our position was that still, there's no defect in this cart, but that's been provided. The second issue was the claims file. Mr. Stern narrowed it down in the motion to, well, that was his point with the claims file. He wanted any motorized cart accidents. So Judge Neary found that was complied with and found it moot at that point. So as far as the overall claims file, obviously we objected that that's not appropriate in a negligence action. Last was the bill of particulars. Judge Neary took a close look at it and found it to be sufficient.
Right, and that's what we'll have to do.
Thank you.
Thank you. 422, S&J Property, oh, I was going to say, Mr. Stern, you can go now. You can go. I'm not going to make you sit there all morning.
How are you?
S&J Properties of Watertown LLC versus the Main Street America Group.
Please the court, Victor Pryle, Smith Silver on behalf of the Main Street Insurance Company. The plaintiff here alleged originally that his building had been struck by a plow.
Doesn't this really sum up an area of wear and tear exclusion?
Yeah.
And that's really what it comes down to, is point blank, is the provision in the contract and whether or not there's been any wear and tear or deterioration. And it appears that your expert has indicated that it was deterioration over a matter of time, your expert, matter of time, and plaintiff's expert doesn't disagree. He says deterioration, but a deterioration over a 2-month period.
That's basically the argument Judge sent around. Yes, I mean,
I would have reiterated that exact same argument you articulated, Judge. I'd
So
add-
that argument we have.
Okay, well, I'll add that I think the second part of it is, so first it's deterioration, he admits it's deterioration. The second part of it is he never tries to parse it out, and there's not even a suggestion that they're arguing for a partial damage caused by that 2-month period. And his opinion is additionally insufficient for that reason. He never provides any baseline from which to go by, if that is their argument. And so if I could just very briefly point out the other two arguments, the one that had not been raised prior to the appeal was that the concept of insurance policy wasn't obtained. Once again, the plaintiff never raised that issue before. The plaintiff never complained about the.
But it's also part of your answer down below. I mean, you provided the exclusion as part of.
Correct, and that was never questioned by either judge. And then just very briefly, the Dyer and Mason affidavits, they were never relied upon, they were never held out to be experts, and they were never even cited by the engineering expert that did provide his opinion.
Thank you.
Thank you.
Good morning, Your Honors. Matthew Ward on behalf of S&J Properties. May it please the court. This case is just filled with issues of fact, and these briefs just show
Let me ask
that
you this
the...
question. You don't dispute, obviously, the wear and tear of the deterioration clause is an exclusion, correct?
We dispute that the deterioration
No, I'm
was
saying
caused by
that-
an outside cause, which would make the exclusion not apply, because this building was built in 1890, I believe. It was maintained. My client bought it in 1999. It has been maintained. There's a track record of maintenance since then. There was no issues. There was no bulge, nothing until the plow truck hit it. Causes a crack in the parging, and then there's almost instantaneous deterioration due to the freeze-thaw cycles.
Yeah, so-
Because it got hit in February.
Yeah, we
It was
understand
a
that.
perfect storm.
I guess, but the question I have is this, once again, is, and correct me if I'm wrong, it appears the defendant's expert says deterioration over time, and when I read your experts, it indicated that there was, deterioration is what they used, but it occurred over a 2-month period.
That's correct.
But he
John.
did use the word that it was a form of deterioration.
Correct. John.
Anything further?
Any other questions?
Thank you.
Thank you.
424, Stephen Pinaro, PhD versus Aphonex, Inc.
Morning, Your Honors. May it please the Court, Tristan Huger for the appellant Athenex. I would like to focus my argument on 3 points of contract interpretation that we believe that the trial court had passed on in 2 respects and went straight to the facts, avoided the contract interpretation analysis, and then another issue of contract interpretation that was incorrectly analyzed. Those 3 issues are the corporate opportunity of Athenex, the confidentiality of Athenex's manufacturing SOPs, and the discretionary nature of the bonus. If time permits, I do have a fact issue and a procedural issue as well that I'd be interested in addressing, but I'll start
Okay,
with.
well,
yes.
remember, though, your opponent isn't here, so.
Right.
We have the papers.
Very good. On the first contract issue, which is the corporate opportunity, this was a matter of contract interpretation, and I would point the court to the Development Manufacturing Services, I'm going to call it the DMS agreement, at section 5.8. The trial court never identified or analyzed that section of the contract. And in New York, as we cite, the corporate opportunity standard is whether the corporation has for example, a prospective business opportunity that provides it with a tangible expectancy or a tangible interest. And the court need look no further than section 5.8 of the DMS agreement, which says that the customer, you for services in this case, has the right to manufacture its own product, and it would look to Athenex for assistance in that situation. What is part of existing cost, baked into cost, is routine reporting and providing of routine documents, but anything further in the bottom of that provision would have to be agreed to by other rates. And we provided the court with an analogous case insofar as a contract would serve as the basis for a corporate opportunity for that tangible expectancy, and that's the Adirondack case where the court found that a mortgage provided the plaintiff with the opportunity to foreclose on the property, and it was the defendant that took that property out from under the plaintiff. And the court noted in that case that that corporate opportunity to foreclose on the mortgage contractually provided a tangible expectancy here. And that's what we asked the court to look at, that's what we asked the trial court to look at, but the trial court passed on the contract and went to the facts and the record, where if this is a contract interpretation question, which we submit that it is, it should start and stop there. The second issue, which is, I'll go to the confidentiality of Athenex's manufacturing SOPs. I'll stay with the same contract, which is the DMS agreement. There's two provisions there, Section 5.4A, which allows you first to have possession of records of work done for it under that contract, and Section 6.2, records of manufacturing of batches for its product. Again, the trial court did not comment on or analyze those two provisions in the agreement on that issue. In fact, it went straight to trade secret law, which we did not even allege in our complaint nor brought up during the case. This is a breach of contract claim for violating a confidentiality provision as part of the employment agreement, and it's this DMS agreement which makes these manufacturing SOPs confidential. What the court should have done was rule that as a matter of law under the contract.
We'll have to decide what the court should have done.
All right. And I would just point out that it is undisputed as to the theft of those manufacturing SOPs. It's undisputed that the whole lot of the manufacturing SOPs were what were taken. In fact, the plaintiff admits that. I'll draw the court's attention to page 764 in the record. His response in an effort to create an issue of fact is that these records are simply not confidential, but again, that ignores the Development Manufacturing Services Agreement. And if you look at the plaintiff's affidavits in this case and the affidavit from Stanley Emerdino, who is supposed to be an expert but is not submitted as an expert, there's nothing supporting these self-serving and conclusory assertions.
Okay, what's your next argument?
The third contract issue is the entitlement to the bonus under the employment agreement. And there, the trial court looked to the third department's decision in Kuiper. I think that was the first of four missteps, because the Kuiper analysis was wrong. In Kuiper, the employment agreement provided an opportunity to earn a bonus based on the performance of certain thresholds. And the question here, which the trial court never addressed, was, well, how do you determine that? And the Kuiper case is distinguishable because that contract, the performance target was based on money. It was fee generation. And the contract said as long as you hit X amount of fees, that triggers the entitlement to the bonus here. But here we're talking about executive-based, quote-unquote, performance standards. We submit that by definition, that must fall to management to determine.
So you say that language, the language in this contract is unquestionably establishes that this was purely discretionary as to whether to award the bonus.
I do, because if we look within the four corners of the document, we are talking about.
But the performance standards would be set by the CEO. Did the CEO say he set them, or that they were followed, or they were met, or did he say he didn't know?
The CEO said that in his deposition that the performance standards were that they were set, and he stated that Dr. Pinero was a good executive, an exemplary executive, I think. Dr. Pinero, in opposition to our motion, referenced certain testimony from Mr. Bessaker, which predated the bonus year. It went to 2014 and 2015.
You know what's interesting is that the contract itself did not refer to this bonus as a discretionary bonus. And a later contract did refer to the bonus as a discretionary bonus.
That's true. What we noticed was that chronologically, and I think if the court's referring to the Doolittle case, this contract actually preceded the Doolittle case, and the offer letter came after the Doolittle case, which included that absolute discretion. But I still submit that this contract satisfies that standard because, again, if we go to executive-based performance standards that are different than what's in Kuiper, which is how much money did someone generate, how can one determine if executive-based performance standards were met? That has to be done at the management level of the company. There has to be discretion involved in that. Oh, okay. Where the trial court went wrong further, though, was in not at least identifying an issue of fact on discretion. We believe the court had two options in this regard, which was to rule for Athenex and rule that as a matter of law, this bonus was absolutely discretionary to Athenex, which we believe it was. Or if not, find an issue of fact, but the court went one step further and determined that as a matter of law, it was not discretionary.
Okay, we understand that's what the
Yeah,
court did. We'll look
right.
at that very carefully.
Counsel, just
Yes.
procedurally, where are we? What's happened in the meanwhile
Thank
down
you.
below? Could
Thank
just
you.
fill us in?
Justice Neuer, that was the procedural issue I wanted to address.
I presumed it was.
Right. So in a week, the trial court is scheduled to hear argument on a motion for a judgment based on a result at trial and a request for attorney's fees under the.
There's been a jury verdict?
It was a jury verdict, yes. It was a jury verdict in November, but there still is no judgment. The plaintiff twice had asked for an interlocutory judgment, once not by motion, once now by motion. At our request, it was adjourned so that there wouldn't be judicial inefficiency, so that all of the judgment-based issues could be taken up in one sitting. And in the course of responding to the plaintiff's motion for an extension of time to respond to this appeal, we noted that we had perfected our appeal, there had been no opposition, and that, frankly, in the interests of justice, so as to not prejudice our client, which did properly perfect, so that there would not be a truncated record on this summary judgment motion in appealing from a judgment, so the court could have full argument and a full record that this appeal remain active. It is possible, I would say it is likely, that we will get a decision on a judgment. I don't know if it'll be in a week, but thereafter our intention would be to inform this court and to ask that this appeal remain active.
Thank you.
Okay. If there are no further questions, I will rest on my brief and ask that the trial court's order be reversed.
Thank you.
Thank you.
425, Jennifer Turner versus Todd Yonker.
Morning, Your Honors. May it please the court. Tyson Blue on behalf of Ms. Turner.
Let me ask some questions before you even get started. You know, the case has a little bit of a tortured procedural history, and that makes it so that by the time we got this case, it's a 2018 order. This is 3.5 years later. You mentioned something in your brief about some things that have happened since 2018, but you don't tell us what they are particularly. So first, I'd like to know what they are, since we're talking about a young child, and that's a lot of time in a child's life, and what those subsequent orders said, because you say something, and it's a little tantalizing here. You say something like, well, it may have the effect of mooting everything, but yet you don't tell us what that is. So why don't you tell us what that is?
Yes, Your Honor. Ms. Turner filed 2 petitions during the pendency of this appeal seeking to modify her visitation. They made, once I learned of them, I got a hold of the papers and the transcripts and found that they did make slight changes to her visitation, but didn't rise to the point that I thought she should withdraw this appeal and start anew. Also, since then, Mr. Yonker has filed a petition seeking to have Ms. Turner's visitation limited to 1 week in August in New York and supervised. That has not yet been decided.
So.
I think that would be a significant.
Sure, that would be a significant change. So what we know still then is that the, Mr. Yonker lives here,
Yes.
Western New York, and the child is with him.
Yes.
And has been since all of these proceedings in 2018?
That's correct.
Okay, and your client moved to California and lives there permanently?
Yes,
Okay, with her other 2 children,
that's correct.
and in the vicinity of the children's father and her family?
Yes.
Okay, and since that time, has there been visitation going back and forth? It sounds like it's been difficult.
It has been, but my client is exercising the visitation she has.
Which is currently
Which
what?
currently,
It's more than once a year.
yes, definitely.
Okay, you know, so, I don't know, I've kind of lost track figuring out what she's actually entitled to, and what she has done. Do we, any illumination on any of that?
I can't tell you off the top of my head, Your Honor.
Okay.
Thank you.
But I would like to use my time to address.
I'm sorry I
Yeah,
took so much of your time, but
That's all right.
basically, you're telling us that you think the court got it wrong, that
Yes.
the child should have been able to relocate with her to California.
That's correct.
Okay, and one thing we do know now is that she has relocated,
Yes,
okay, without the child.
yes.
Okay.
And she has.
Tell us what the court got wrong.
All right. The attorney for the child's brief argues that the court erred in going forward with a hearing, even though there had been a consent order only a few weeks prior, and that there was no evidence of a change of circumstances. Would be our position that the parties all submitted to the court's jurisdiction, they presented evidence. Mr. Deneri's brief states that it was 15 days, but that 15 days was actually spread out over a year and a half.
True.
So that after all this extensive testimony, plus 3 more trips to the well, essentially, that it's a little late to be going back to that issue. And the court stated at the outset when the issue was raised that he was going to give my client a full and fair hearing.
That's right.
And did so.
Okay, is there anything further?
Just a couple of brief things, responding mostly to Mr. Deneri's arguments. He argues that where a parent interferes with the relationship with the child and a non-custodial parent, that such is evidence that the interfering parent acts contrary to the best interests of the child. Obviously, that was intended to refer to my client's actions. However, in view of his current petition, it would be our position that it would apply equally to his own conduct.
Okay, but that's not before.
That's not before.
Not before
so
the
we
court.
can't- Okay, do you have anything else?
I think that my arguments for the court have, considering the importance of the relationship and the bond between the child and his other siblings in California.
It certainly doesn't trump the bond between a father who wants to be with the child and the child. Half siblings do not trump parents.
And the court
I wouldn't
did-
necessarily agree with that, Your Honor, but
Okay, we'll
I
look
do
at,
see
we'll
the
look at all that.
argument.
Thank you very much.
Right. It's not like the court ignored that. They did discuss it.
well, for about 60 words, Your Honor, I think it
Okay,
certainly
we'll look
deserved
at all
more than that.
Thank you.
Thank you.
427, Todd Solansky versus Jeffrey Emprick.
Good morning, Your Honors. May it please the court. I am Stan Cohen, attorney for Todd Solansky. We have a minority shareholder. We're in a shareholders agreement with 3 minority shareholders.
Counselors, you heard us throughout the day, the morning. We're familiar with the records. When I was looking at the briefs and going through this, it appears, and I don't want to simplify it because it's a complicated case to a certain extent, is that there's a narrow issue here, and the issue is whether there was a breach of the shareholders agreement. That to me to be the heart of this whole argument, the heart, and from that flows everything else.
Right.
Okay,
I
so
agree with that.
tell us why because their argument is that this is in contravention of the BCL, and therefore it can't be applicable, and so on. So tell us
Right.
why this is a violation.
Okay, so shares to be issued have to be issued either with consent, which obviously it wasn't, or in accordance with the agreement. The shareholders agreement has that's at Article 13. The shareholders agreement has a statement that the certificate of incorporation cannot be amended except with all of the shareholders. They say, the BCL in 802, says that you need that in the certificate of incorporation. The shareholders agreement does not apply or cannot apply to usurp the BCL. BCL 620 says that shareholders can make agreements amongst themselves as long as they are the shareholders that all the shareholders agree.
And that's what happened here.
That's what happened here. Not only that, there's a long lineage of cases, which I have cited, which establish that even if it's not in the certificate of incorporation, the supermajority, that there are rights for the court to say, we liberally apply what the shareholders intended in their agreement, and we will not bar that because of a provision in the act.
So let me ask you a little bit about the agreement. It seems to me that while they didn't have the consent to issue the additional shares, it seems that the shares were issued in accordance with the agreement, but I might see a problem with them amending the CI without the plaintiff's approval.
Right, but then they couldn't have issued the thousands of shares that they issued, because the certificate of incorporation only had 200 shares authorized. So that was part of the plan. The valuation also was required under the shareholders agreement, and the valuation, and they say that the valuation was inapplicable here. But the valuation provision, paragraph 31, says there's a procedure that must be followed if the shareholders cannot agree on fair market value for whatever reasons. And that's the cause. It's an open-ended, for whatever reasons. They say it's only applicable to certain provisions, but the clear language says for whatever reason. So I think that's another reason why the shares were not done right, that they were not authorized to do any of the acts.
We only get to that is if we get to we only get to that issue is if we find that they were able to give the shares. Valuation only comes about, at least my understanding it, valuation only comes about if they were properly able to convene and distribute new shares.
Oh, okay, yeah, there's a basic premise that starts with they were not
Right,
authorized.
so we don't get to the other issue.
But we do, but obviously then valuation becomes an issue if it was properly complied with.
Correct, but that is the secondary issue, and I agree with you on that 100%. But it is something that they did wrong again. And it goes to, did they issue the shares as was required in accordance with the shareholders agreement?
Anything further?
Yeah, just there is one point that, well, there are a couple other points I want to make. The derivative actions were also dismissed, and there is pleadings, there is.
I know, Counselor, but I looked at that. You don't seem to be addressing that in your reply brief.
Right now,
Okay,
for
I'm
this
just
appeal, we want Mr. Solansky to be
understand
restored
this.
to his
Derivative
45%
issues,
interest.
okay.
Once again, you are right. That's the issue here. That his share interest was diminished from 45% to under 3%, and the majority, we believe unjustly enriched
It's
themselves.
an
by
individual
doing so.
claim, it's not really It's not a claim of harm to the corporation.
Well, but the case, if it gets remanded, the case has many issues that go to the harms to the corporation.
No, but for
by
purposes
the
of this
majority.
appeal, right.
Right, but for this appeal, it is, the 45% should be
Right.
restored. We would ask the court, and there is a Court of Appeals case that I cited in my brief, we would ask the court to actually also order a reformation of the certificate of incorporation.
Counselor, when I look at the relief down below, you really requested for an expedited type of trial and discovery. I didn't see down below where you've asked for the relief.
Down below, I didn't even ask for summary judgment.
No, I know, but you didn't, there's no relief other than, one of the things you mentioned was the fact that you wanted to go back on an I thought I read, on an expedited discovery trial type of process.
Oh, no, Your Honor, I was just, not expedited, I was just saying if it gets remanded, all the causes of action should be
Okay.
restored, and, because the causes of actions were dismissed, and therefore it would go to discovery and trial on everything. But right now, there is that initial issue, which we think is rather important, that we have a 45% shareholder, not an under 3% shareholder.
Okay, I think you made your argument.
Thank you, Your Honor.
Good morning, Your Honors. John Collins for the defendants here. And our position is that the trial court properly granted defendants' motion for summary judgment dismissing all claims based on their alleged violation of the shareholder agreement. The court, I note, did not grant summary judgment entirely. The first cause of action for breach of fiduciary duty survives, except to the extent predicated on that breach claim. And Mr. Solansky's breach of employment agreement claim also survives. But as to the claims based on breach of the shareholder agreement, it's our position, and the trial court agreed, and the record establishes that the under sections 13 and 14 of the shareholder agreement, the shares were properly issued on majority vote of the shareholders, because unanimity and written agreement by all shareholders required only where shares are issued.
Counsel, are you referring to the certificate of incorporation?
No, I am not. I'm referring to the shareholder agreement. Okay. The certificate of incorporation arose kind of during the course of this litigation. It was not mentioned in the complaint at all.
Fair enough. Yep.
And the trial court did, during the pendency of this motion, permit Mr. Solansky to also raise an issue regarding the certificate of incorporation. But as to the complaint itself, the issue is really, was the shareholder agreement breached by issuance of shares, any shares, without unanimous written approval of all shareholders?
Isn't there also a question as to whether the certificate of incorporation was properly amended without the plaintiff's approval? Because that requires unanimity.
That is the argument, but I submit that it doesn't require unanimity. I mean, first of all, I note that the original certificate of incorporation authorized the issuance of up to 200 shares, so unquestionably, the two shareholder defendants, Mr. Emprick and Ms. Lucas, could have voted to authorize the issuance of 100 shares. But I submit that there's no merit to the claim that they weren't authorized as majority shareholders and majority directors to ultimately to amend the certificate of incorporation based upon the provision of Business Corporation Law 803A, which provides that if anything other than a majority, such as a supermajority or unanimity, is going to be required to amend the certificate of incorporation, then it has to be set forth therein.
Well, it is though, isn't it?
No, it is not in the certificate of incorporation.
It's in the shareholders agreement.
Yes,
And
but the shareholders agreement.
Section 3 or 4 refers to bylaws and certificate of incorporation will be read as subject to the provisions of this agreement, meaning the shareholders agreement. So certificate of incorporation is to be read that way. It goes on further to say, and they will not be amended, so on and so forth, except with written agreement of all shareholders.
But Section 41 of the shareholders agreement also says that if there is a conflict between the certificate, or rather the shareholders agreement and the provisions of the business corporation law, the business corporation law shall be deemed to control.
But there isn't a conflict. I don't see any conflict between that clause and the business corporation law. The business corporation law allows for parties to require unanimity.
But only if it's spelled out in the certificate of incorporation, and it's not. And I think that
Oh, yeah, we just had that conversation.
Yeah. But, so, it's our position that under Section 41, what controls here is Section 803A of the BCL, which requires that anything beyond a simple majority has to be set forth in the business, or in the certificate of incorporation, and it is not. And for that reason, the shareholders, and I note that, this was done not for any underhanded reason, as it is implied. I mean, the corporation was on financial ropes, had a value of about $35,000, a $400,000 note coming through, and what Mr. Emprick and Ms. Lucas did is invest $500,000, and in exchange for that, they got the shares that they, as majority shareholders, properly authorized. The alternative was default, probable bankruptcy, and everything they did was to preserve the corporation's existence and, future viability. And they also, permissibly under, as the trial court found, permissibly under the shareholder agreement, retained Lumsden McCormick and its subsidiary Brisbane to perform the evaluation that was used to determine, what the value of each share is, and therefore how many shares should be issued in exchange for that $500,000.
Thank you.
Thank you, Your Honor.
428, the Campaign for Buffalo History versus City of Buffalo.
Good afternoon, Your Honors, and may it please the court. My name is Richard Lippis, and with my co-counsel who is with me here today, Richard Berger, we represent the petitioners. And there's only a few points that we made, both in a brief and that we will make today.
So let me start right out. You agree that the standard of review for us and the standard of review that was required for Judge Kaliakovo was whether the determination by the commissioner was arbitrary and capricious, right?
Yes.
Okay. So, and as I understand your argument, the big problem, you say, with the decision is that you were prevented from making any showing that the determination was arbitrary and capricious because he limited the proof at the hearing.
Yes, that's our first point. Do you have another question?
Nope.
Oh,
You may proceed.
Yes. And as we just indicated, our jurisprudence requires that all parties have a fair opportunity to
Right,
present
and
their evidence.
you weren't allowed to put any proof in, correct?
I'm sorry?
You weren't allowed to put any proof in at that point. You were not allowed to put any proof in at that point.
What did you say?
We were not allowed to put any proof in at that
Yes,
point.
that's correct. That's correct. And it actually exacerbated what the commissioner did, because he also did not make any attempts to contact a preservation architect or engineer to see whether or not, in fact, the building was a danger, and whether or not, if it was a danger, the danger could be abated. So that in and of itself, we believe, is an abuse of discretion on the part of the trial judge, and requires this court to reverse, and to give us an opportunity to present our evidence. The second issue deals with the Buffalo Preservation Ordinance, which requires the commissioner to determine whether any hazard could be abated so that a reference could be made to the Preservation Board. And when Commissioner Comerford was asked about whether or not there might be ways to abate, and he indicated in his testimony that he doesn't consider solutions, but that's not his job. We specifically asked him, for example, what about hanging metal sheathing like a drape around the building? And again, he said, I'm not going to consider your potential abatement considerations. So he didn't consider any of the solutions or abatement solutions, which he would have had to have done in order to comply with section 337-28.
But this, excuse me, but this, the argument is that this grain elevator presented an immediate threat to safety of the citizens, the people who might be in the area. So I'm not so sure that all of that is required when you've got an immediate threat situation. So that's the situation, that's how it was presented to the commissioner.
Yes, that was presented to the commissioner. However, the fact is that the commissioner determined that there was an imminent threat.
He agreed
only
with
based upon listening to ADM's experts and his own staff.
Isn't he entitled to do that at that point?
Well, he based his decision on wrong facts. And if he had heard...
And you attempted to tell him some additional facts, is that right?
I'm sorry?
And you attempted to tell him some additional facts.
Oh, yes.
You know, both before Commissioner Comerford and before Judge Koliakova.
And the commissioner not only did not reach out to get additional facts from the other side or from a preservation architect, but he also based his opinion either on issues that he admitted in his testimony he had no knowledge of, or that he just based them on facts that were incorrect. For example, in his first point, he indicated that the Great Northern was vacant and abandoned. Well, it wasn't abandoned. The ADM used the land for a parking lot, and they mowed the lawn and maintained it.
Okay, all those kind of things we'll look at very carefully.
Pardon me?
We'll look at all those factors very carefully.
Yes. I also would like to point out that the historic Albany versus Fisher case, which the respondents relied on very heavily, both below and in this court. In that case, is clearly distinguishable because the building commissioner in that case did exactly what we said the building commissioner should do. When he had two different experts saying two different things, he ordered an independent evaluation of the building by a structural engineer. That's exactly what we said.
Then he had all sides and an independent review.
Yes, and that's what we said.
In this case, there's only one side. That's
Pardon
your
me?
argument. And in this case, there was only one side presented.
Yes, only one side.
Okay, I think we have that argument.
In order to rationally make his decision, he had to hear both sides.
I think you've made that argument, I think we understand.
Especially when you understand that he simply didn't know so much about the building. And of course, I won't go into the history and the importance of the building because you got that.
We're aware of that. Thank you.
Good morning, Your Honors. David Lee for the respondent, City of Buffalo. The first point to make, I think, is that the commissioner made his determination based on what was in front of him at the time he made his determination. At that time, the Preservation Board, or I should say, I beg your pardon, the coalition had not submitted anything to the commissioner, nor did anyone associated with the coalition have anything in front of the commissioner. So the commissioner made his determination based on what was in front of him at the time, and that's really the correct standard that we have to go off of here. Now, fast forward to the hearing, which wasn't even really required. I mean, Article 78 proceedings happen all the time, and it's actually pretty rare that there's a hearing.
But the court did convene a hearing, a fact-finding hearing, okay? So I think we would assume that they're looking for the facts. You know, because.
Absolutely, Judge, but it's what facts are important. And so what's being reviewed here? It's rationality. It's did the commissioner's determination have a rational basis? So let's say if this court
Well,
were.
is that the standard of review, or is the standard of review whether it was arbitrary and capricious?
I think from my understanding, we're saying the same thing. It's either rational or it's arbitrary and capricious. So we're trying to figure out, is there a rational basis in the record?
So when there's a challenge made to the determination, how do you prevent the challenger from making a showing as to whether the determination is arbitrary and capricious by presenting evidence?
Right, Judge. And Judge Koyako did have all the petitioner's evidence before him. It's not like the lower court did not consider petitioner's evidence. It did.
Oh.
It had petitioner's affidavits. It
Okay,
just,
but the record is clear that they wanted to offer testimony of an expert, and were told by the court that's not necessary.
and if you look, and I think Judge Koyako was right on that, because if you look at the case law, in an Article 78 proceeding, we don't weigh evidence. We don't sit here and, it's not the court's role respectfully to say, oh, well, petitioner's expert said this, and city's expert said this.
No, but you review it. I mean, it's relevant in determining whether the determination was, as you say, rationally made or not, whether it has a rational basis or not.
But let's say if the court remands this back for further proceedings. The evidence that's in the record right now that was before the court is not just going to go away. So, and that's kind of I think
I think we agree with that.
Yeah, I
Right.
don't dispute that.
So what's going to happen is the petitioner.
The question is whether the record should be more expansive or not.
But if it is more expansive, what is the best case scenario for the petitioner? It's that they have experts who disagree with the commissioner's determination. And there is case law cited in our briefs that is not going to be enough to annul the determination of the commissioner. So I think what we would be doing is be sort of wasting.
Well, I don't know that I agree with that. It depends on the nature of the proof that's offered. It depends on the nature of the opinions. I mean, if the opinions establish that there's no rational basis for the commissioner's conclusion, I mean, it seems to me that evidence could come forth establishing that, or not.
Right.
Or
But
not, right.
I would say, Judge, though, we do know what the proof is going to be in the sense that we do know what petitioner's affidavits say. So those would be the experts. They would.
But we may need to have that actual testimony. Anything further?
No, Your Honor.
Good morning, Your Honors. May it please the Court. Ed Markarian for Respondent ADM. I'd like to start out by saying that the standard of review is not what the questions may be suggesting. This is an Article 78 proceeding, and the rational basis is the same as the arbitrary and capricious standard. If it's rational, then it's not arbitrary and capricious. And the standard is, what did the commissioner have in front of him? Did he have
Is it what he had in front of him or what he could have had in front of him?
Well, the question, Your Honor, is did he go through a thorough enough process to have a rational basis? So you have to look
But
at
if you exclude all evidence on the other side and just take one side, how are we to determine whether it's a rational basis or not? If there were irrational things that other people could point to, he just didn't want to hear it.
That cannot and is not, cannot be and is not the standard of review for emergency Article 78 decisions. It cannot be. These have to be made on an expedited basis. That's why the law gives the commissioner emergency powers. He has to make a quick decision. If we're going to have de novo review, expanded hearings in emergency situations, it's a recipe for disaster, and it's not what the law says. So if the commissioner did not gather any proof, that would be arbitrary and capricious. If he gathered proof that was woefully inadequate, maybe it could be arbitrary and capricious. But the standard is rational, and rational means he had a basis in fact for his decision. The law is well settled. It does not matter if third parties, such as the petitioner, disagree. The law is so well settled that even a court, if it would have reached a different conclusion, it does not affect whether the decision is rational, so long as it has a basis in fact. So let's look at what the commissioner did here. He had a 6-step fact-finding process. Step 1, he went out and he saw the building. And this is an extraordinary collapse. I don't recall ever hearing of anything like this. This is so extraordinary, and that's step 1.
Is it so extraordinary, or isn't it exactly the same as a collapse of that same wall once before?
No, this is a 10-story collapse. It never happened. I can't remember, as a Buffalonian, ever hearing of anything like this. This is a 10-story wall collapse spreading a debris field 120 feet. I mean, think of it in context of Labor Law 240. This is an unbelievable first step, and that was only step 1 of his fact gathering. Step 2, he assembled his team. He did not make this decision alone. He's an expert. The assistant director has an engineering degree. He's got a staff of demolition experts. He assembled his team,
Okay, what's
including
step
the
3?
fire commissioner.
What's step 3?
Step 3 is he did the drone examination, and that's critical here. You have to look at what the drone shows.
Did he take all of his steps after he received your client's engineering report?
It was all happening at the same time. I can give you the
Jenny?
chronology, Judge, if that would help. So the event occurs on December 11. The staff is looking at it on December 12. December 13, the commissioner does his personal inspection. He meets with the engineer and with counsel on the 13th. The drone inspection is on the 14th.
With your engineer?
Yes.
Shenny?
Yes.
Yeah, okay.
But the report isn't in yet. On 14, he does the drone inspection, and then he receives the reports. And it's not just one report now, it's 4 reports. And I know we're talking about, we would like to have input from everybody. That would be wonderful in a non-emergency situation. But the commissioner's allowed to use his judgment. In fact, he's the public servant who has to make these tough calls. He's got to filter what evidence is going to help him or not. He knows, because step 5 is he calls the chair of the preservation board. He talks to her. She signals what the preservation community's position is. She says, you're going to get pushback. She advocates for not demolishing, so he did get input.
That was a telephone call?
Yes, that's correct, Your Honor. There was no, by the way, Your Honor, if you look at the unsigned affidavit of Mr. McDonald, it says he's reviewing the drone footage at the same time. So it's not like they're out of the loop. They're in the loop and they're not coming forward. So step 5 is he calls the preservation board chair. And step 6, he brings in the fire commissioner. The fire commissioner is another neutral party. He has no stake in this. His job and the building commissioner's job are the same. They protect the public. That's what they do. They don't go with public opinion. They don't do what's popular. Their job is to protect the public. So now you have 2 public officials doing independent reviews coming to the same conclusion. So that's a 6-step thorough process. And the fact that the commissioner makes the judgment, which he's allowed to make, that he doesn't have to hear further from the preservation community because he already knows what they're going to say. and they're not neutral.
Okay,
And you can
I think we have that argument.
You can say that ADM is not neutral, but that would not be correct, because ADM, unlike the preservation community, they have a stake in this. They're liable for public safety situations, just like the city. Also, to say that these are ADM's reports is not true. They're engineers' reports. They're signed by licensed engineers, and they became instantly credible once the collapse occurred.
What about, let's fast forward to the hearing.
Yes.
What about the limitation on the proof?
Well, it goes back to what did the commissioner need to have in front of him? If he had sufficient evidence in front of him, and the standard is rational, did he gather enough evidence to make a rational decision? Meaning he's got a basis in fact. So he's gathered enough evidence to make a rational decision. Then the only issue for the hearing is, how did you go about your decision-making process? You don't bring in and have a de novo review. That would set terrible precedent in
Okay,
emergency
I think
situations.
you've already said that.
Right, because now you're delaying.
Okay, I think we got that
But even,
argument.
even in the Albany case,
We had both sides.
the court permitted proof from
It was
the
a-
challengers.
It was a different procedural context, but the important, and it wasn't like this with an emergency and it came in, I don't recall that the commissioner solicited the report. It came in because the preservation board put it in. And the commissioner said, I'm not persuaded by it. I get to make the call. And that's the point. The commissioner here, he gets to make the call. And so long as he gathered sufficient facts and he gathered
Okay,
extensive
again,
facts.
you've gone over that and over that. Do you have anything further?
Yes, Your Honor. I think that's the bottom line here. This is Article 78. Is it rational? And it was rational. Did he have a rational basis, which is also the test? It was a rational basis without soliciting the views of non-biased parties. And he rendered a conclusion that should be upheld, because if we don't,
Okay, again, you said all that.
yes, Your Honor.
Thank you.
We ask that the court affirm and protect the Article 78 process for emergency review. Thank you, Your Honor.
Thank you. 429, People of the State of New York versus Todd Baxter.
Good morning, Your Honor. Jonathan Garvin, may it please the court. Jonathan Garvin for petitioners, may it please the court. The sweeping parole reform known as,
Here's my main question here.
yes, Your Honor.
Why would this be retroactive?
Yes, let's talk about that, because we have to be precise with what the petitioners mean by retroactive, because we are talking about a procedural and remedial
That's why I'm asking
statute.
you.
Okay, so a procedural statute falls under the exception where, and this New York statute sections 54 and 55 explain what we really mean by retroactive.
It usually falls within an exception for proceedings that are already underway. This proceeding wasn't underway until you brought it, and there wasn't, these petitioners didn't have a pending proceeding. And it seems to me that with respect to this legislation, the legislature easily could have included language ordering these reconnaissance hearings for parole detainees that were being held on existing warrants, but they didn't.
Your Honor, because procedural statutes are generally considered retroactive with respect to pending cases, which we maintain that these are pending cases, the legislative silence would make sense because because what New York statutes 54 and 55 make clear is that when you're talking about procedural and remedial statute, you look for legislative intent for it not to be retroactive. And there is no claim that there's any language that shows clear intent that it's not supposed to be retroactive to the degree that we're talking about for claims that are going forward. Not, unlike all the other cases that deal with retroactivity, we were dealing with, one, substantive rights, which there's no claim that the respondents have a substantive right are at play, or two, whether the, I'm sorry. Okay, there really wasn't any dispute that these are procedural statutes.
No,
but-
we understand.
Okay.
Again,
So there,
Go ahead.
sorry, okay. Before less is more, it was sufficient for a warrant to have an accusation for the respondent to.
We understand all that, and we know
Okay.
what happened
So
after this, yes.
the legislator showed its intent by effectively repealing the old automatic and mandatory detention. They put in other warrants are pending a recognizance hearing. They put that in without limitation. They put that in without tying it to anything. That is how they're showing that they meant for the warrant.
Okay, that's, we're
And
going to
that's-
have to look at that very
Let
carefully.
me ask you a question. This is a habeas corpus proceeding, and as I understand it, each petitioner has secured release, either by paying bail or by operation of law. So they've gotten the relief that we could give in a habeas corpus petition.
Your Honor, they've gotten release as far as the Article 539 aspect to it, but not.
They're not being detained. They're no
They're
longer
being detained on parole, they still have parole holds, and that's the sole basis for their being
The
detained.
parole holds, they're being a parole hold, but they're not being incarcerated while they're being by this parole hold. I guess the question is this, is that, are any of these people still incarcerated as a result of the action?
The
Because
sole basis, they're currently in
It's a
jail.
simple question. Is anybody incarcerated right now as a result of this, of the parole hold?
Yeah, all of them are
And they're-
incarcerated.
And have they had a hearing?
No, they've not had a hearing. They've not had a recognizant hearing. And because of that, we believe they're being illegally detained. That's why we're here seeking habeas relief.
So they have not been released? Is that what you just said?
Since we filed papers here, there have been some that have been released. So those cases we would concede would be moot. But most of the people are still being held on parole holds.
Without any hearing.
But they're not, are they incarcerated? Are any of them incarcerated?
They are all, unless they've been released, there's a handful that have been released.
It's a pretty simple question. Are they incarcerated or not?
Your Honor, I'm just trying to be accurate to say that there have been some people have been released, but for the most, we're talking about people who have not been released. They're still incarcerated, they're still in jail on parole holds.
Still in jail on parole holds, not everyone, but some of them, correct?
The majority, but not everyone.
Okay, that's it. That's it.
Okay. Thank you.
If there are no further questions, we request that this court immediately release them pursuant to less is more or any alternative to order recognizance hearings forthwith, as was done in the Ramirez case in the Bronx, for which the people did not appeal or say there was anything improper with that.
Thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court, Kate Neville for Respondent Annucci. Your Honors, as the court has already pointed out, the legislature could have and did not direct that recognizance hearings be applied retroactively. The Less is More Act effectively created two completely new things in the area of community supervision.
Should we apply it retroactively anyway?
No, Your Honor.
Because it's a procedural statute.
No, Your Honor, because the
Why?
right to a recognizance hearing is effectively a new right, the right for a court to decide whether the releasee needs to be detained in order to to guarantee appearance at the preliminary and final revocation hearings. The legislature chose to explicitly make one of the new concepts, essentially, the earned time credit retroactive, did not do so for recognizance hearings.
Yeah, that's what struck me, is they did make part of it retroactive.
Yes, precisely, Your Honor. And that by itself might be enough to indicate that the legislature did not intend retroactivity here, but there's more. The structure of the statute indicates that recognizance hearings were meant to be part of a complete process that began on the effective date with the issuance of warrants under the new statute. The issuance of warrants, then there's a recognizance hearing. The preliminary and final hearings, the timing of those depends on the outcome of the recognizance hearing. And the effective date of the statute was
March
not
1st.
immediate, but was postponed. Your Honors, I'd be happy to answer further questions about the retroactivity, but I did want to make one point with regard to any potential relief, should the court believe that's warranted. I'd just like to point out that it's very important that docs be given the opportunity to put forth its case for detention at recognizance hearings, because it maintains a supervisory role over these releasees, and so it knows their community tie. Yes, Your Honor.
Have those been scheduled for the folks that still remain incarcerated? Do you
No,
have-
Your Honor, because they've already had their preliminary hearings or they've waived them. They're all waiting for their final revocation hearings. Recognizance hearings apply under the terms of the statute to warrants that are issued and executed after the effective
March
date.
1st.
Yes, Your Honor. So I'd just like to point out that there's no basis for immediate relief in any circumstances. At most, petitioners will be entitled to recognizance hearings, but the way the statute is phrased does not give them that retroactive right. Unless
you.
the court has questions, we would ask the petition be denied.
Thank you
Thank you,
both
Your
very
Honors.
much. This term of court is adjourned until April 20th.